Be ready? Start. From the perusal of the records, the court is of the view that from the beginning, delinquents had not been cooperating in the disciplinary proceedings and had been raising frivolous objections regarding the constitution of the disciplinary committee, possibly with a view to make out a ground subsequently to challenge the decision taken against them. Stop. A perusal of the letter dated 24/8/2009 and the subsequent letter dated 25/8/2009 annexed as Annexure 4 to the supplementary counter affidavit reveals that all along the delinquents had been raising objections as to the entitlement of the governing body to manage the college in question vis-a-vis some other body which according to them was the rightful authority to run and manage the college. Stop. The said letters leave no doubt that the delinquents had some vested interest with such other body which was also claiming management of the college. Stop. In this regard, it is relevant to refer to the earlier judgment dated 16/4/2010 wherein this issue was considered and this court, after due inquiry from the Learned Counsel for University, categorically held that there was no such dispute with regard to the governing body in question. Stop. The court is of the view that delinquents being employees that two teachers of the college, there was no valid reason for them to take sides with either of the parties in any dispute of management of the college, assuming the same existed, though in view of the judgment dated 16/4/2010 there was none. Stop. Such conduct on the part of the delinquents, coupled with the serious allegations levelled against them, was quite uncalled for. Stop. In view of the above, we find that the finding of the Vice Chancellor with regard to the constitution of the disciplinary committee on the basis of inclusion of Shri Vijay Kumar is not sustainable. Stop. Stanza. The other ground mentioned by the Vice Chancellor is the inclusion of Shri Danial Singh as one of the members. Stop. This ground on the face of it is not acceptable for the reason that on 1/9/2009 itself Shri Danial Singh was substituted by another member, Shri Balwant Singh. Stop. Moreover, the alleged mental health of Shri Danial Singh had not been proved and he had rescued himself from the proceedings not on the ground of mental health but on the ground of physical ailment relating to his back inquiry. Stop. In any case, after 1/9/2009, he was not a party to the proceedings, but the Vice Chancellor failed to notice this fact. Stop. The other reason given by the Vice Chancellor that there was denial of opportunity as to weeks time requested by the delinquents for submitting the reply to the letter dated 11/10/2009 was not granted is concerned. The same is also misconceived. Stop. It appears that the Vice Chancellor has not perused the documents on record carefully and has not drawn conclusions based thereon. Stop. After issuance of the letter dated 5/10/2009 and the reply of the respondent's wide letter dated 12/10/2009, the governing body did not take any action against them till 28/10/2009. Stop. Stanza. We are of the view that ample opportunity was given to the respondents to defend themselves and file a reply in response to the letter dated 12/10/2009, but no reply was filed by them. Therefore, observations of the Vice Chancellor are absolutely perverse. Stop. In view of the above discussion, we are of the view that so far as the first question framed by us is concerned, the Vice Chancellor has not exceeded his powers on the issue relating to the validity of the constitution of the disciplinary committee and other related issues are concerned, as they were germane to the satisfaction required to be recorded regarding the procedure prescribed having been followed or not stopped. He, however, appears to have clearly exceeded his jurisdiction in the manner in which he exercised his power, as he virtually acted like a trial court or an appellate authority. Stop. The Vice Chancellor has failed to appreciate the distinction between Section 35 within bracket 2 and its proviso, forgetting that the legislature, by virtue of the proviso to Section 35 within bracket 2, intended to confer a very limited role for the Vice Chancellor to perform a role much more limited than the one contemplated. Stop. Stanza. Learned counsel for the appellant has argued that once there was a valid insurance policy operating as on the date of accident, documents in relation whereof were duly produced before the tribunal, there was no reason or justification for the tribunal to have recorded a self-contradictory finding in the award to the effect that the offending vehicle was not insured as on the date of accident. As such, the said finding is perverse. Stop. This court, in order to test the submissions advanced, has gone through the original record summoned before this court, and it is found that a copy of the original policy bearing premium receipt number as on 24/6/1999 is on record. Stop. Once the original policy is in the list of documents filed before the tribunal, then in such a situation, recording a contradictory finding to raise a doubt about the validity of insurance of the vehicle on the relevant date is clearly erroneous and baseless. Stop. The contradictory finding recorded by the tribunal that the vehicle was not insured being perverse is hereby set aside, and the vehicle is treated to be covered under the insurance policy, particularly when the same remained unquestionable. Stop. Recording of a finding in relation to insurance policy in favor of the owner within bracket appellant herein goes to establish only one ground, but in so far as the other ground of driving license and its validity is concerned, the same being decided against the appellants is strongly contested by the insurance company represented by Sri Sachin, learned counsel. Stop. Stanza. The tribunal, while deciding the claims, has found that though the photocopy of the driving license is said to have been issued on 12/5/1986 was placed on record, but the date of its validity was not legible, which lead to a doubt for recording a finding in favor of the appellant. Stop. It is worthwhile to mention that the driver of the offending vehicle has not participated in the proceedings, and the original license was also not filed before the tribunal, so as to clear the doubt which was noticed on the photocopy of the driving license. Stop. As per the stand taken by the insurance company in its written statement filed before the tribunal, the validity of the driving license was disputed. Stop. The issue framed on this aspect of the matter was duly gone into by the tribunal, which appears to be assailed before this court baselessly and without bringing on record any prima facie or conclusive evidence on the basis of which this court may come to a different conclusion. Stop. During pendency of these appeals, an application for disposal of interim relief application was, however, filed on 5/9/2014, and some documents were placed on record along with the said application, which includes the document alleged to have been obtained by the appellant under Right to Information Act on 9/12/2009. Stop. The said information relates to the driving license indicating its validity as on the date of accident, but the information is seriously disputed by the insurance company. Stop. The question that immediately crops up is as to whether stop over.